Now it's my pleasure to introduce today's speaker, who you have already met in the past, Liz Bailey, who is our legal and regulatory expert on the core panel. Liz is a specialist on the management side of employment law at Sheehan Finney, New Hampshire law firm. And she works with a diversity of clients, both in the public sector and in the private sector, around employment issues. So Liz, we're really happy to have you present to us today. Thanks so much.
Thank you. My colleague Andrea is with me remotely, and if we could pull up our slides now, I'll take you through them. What I'm trying to do today is that I recognize we have a great diversity in our group, and some people are directly involved in human resources and some people are not. And some people come from big employers or small employers. So we approach these things from a variety of different perspectives. So what I thought I could do for the next 20 minutes or so is just kind of give a broad overview about what I think most of us will be confronting or having to address when we return to work. Even if we're not directly responsible for some of these issues, at least to kind of get us talking about them and thinking about them, and maybe have them be a red flag to you if somebody comes in and raises this issue with you. So if, Andrea, if you could advance the slide. So for today's agenda, again, just thinking about some of the common things I think we all might be running into that are legal or regulatory: compliance with state emergency orders, employer policies, the EEOC's guidance about the Americans with Disabilities Act that we might be addressing, the Families First Coronavirus Response Act, and which creates a series of leaves we didn't have 3 months ago, and also compliance with anti-discrimination, anti-retaliation laws, some other return to work issues that are common for folks to need to address, and some liability considerations. And just to remind us, we're all in this together, where this is all a learning experience for us all in this brave new world. Next slide. So executive orders. In the end of my slides, I have a lot of different resources, and one of the resources that Dr. McClellan had provided earlier in our ECHO group was a really great state-by-state executive order resource, which you will see again in my resources. But I know we come from different states, and each state has its own set of executive orders at this point. They're important for us all to be mindful of and to consider and to pay attention to, because they are a really great roadmap as to how we are supposed to return to work with one another. So we all should be looking very carefully and following those executive orders. Many of them, and this is all, try to generalize a little bit, but many of them contain universal guidelines, which would apply to really all workplaces. But they also contain very handy industry-specific guidelines, which are great to look at for your own business. It's important to monitor these executive orders. We have all seen throughout the pandemic that just when we think we've mastered something, it changes. A law changes or guidance changes. So same holds true with executive orders. You could go to the next slide. So what are some common features of them? Generally, the governors are not going out on their own. They're not trying to, set forth their own agenda, but they're really trying to take steps that they feel are consistent with CDC, OSHA, EEOC guidance, or other federal health and safety agencies. And they're trying to encapsulate all of these concepts into orders that apply to us all. The orders generally communicate about COVID-19 prevention efforts, what we should be doing preventatively. They address perhaps emergency illness policies. If you don't have one, getting one in place. If you do have a policy, making it COVID-19 specific. They talk about federal, the Families First Act compliance. That new leave is another leave available to us all we didn't have before, which is very handy in a return to work setting. What do we do to plan for potential COVID-19 cases? What should we be doing about PPE? What do we have for a protocol if employees are sick? And that doesn't necessarily need to be a confirmed case of COVID-19, but when we are learning about an employee being ill, promoting frequent hygiene, talking about remote work and encouraging it, even though some businesses are back open. There is a strong encouragement to allow people to continue to remote work if they can. What employers should do for screening processes, what we should be thinking about when we get back to work with one another about social distancing, and also workplace cleaning and disinfection processes. And I know we have talked about a lot of these really granular things in past ECHO sessions and have gotten some great guidance and great feedback. Next slide, please. So policies. I don't think any of us had a policy around 3 months ago that dealt with COVID-19 issues. Some very sophisticated employers, some people who were really ahead of the curve already had pandemic policies. A lot of employers do, but a lot of employers don't. So now we are in a situation where we've got to be creating, the illness policy, for instance, to address what do we do about COVID-19. Next slide. Some policies and some policy considerations when we're thinking about policies is, again, the screening. What do we have for PPEs? What are we providing? What are we encouraging people to have? What is our emergency sick leave? A lot of people may have gone through sick leave already before this pandemic hit us all. What are we going to do about our existing sick leave policies and availability? Could that be expanded? Could that be extended in some way? We all have been maybe out of work or working remotely for a while now. What does this mean about what we had already for unpaid leave or for borrowing from leave time? So what if you have somebody that now needs to be out some more because of COVID-19, but they've run out of leave? Do we grant them unpaid leave? Do we maybe let them borrow against leave that they don't already have? What about some thinking through some policies about break time for hygiene? If we need people to go wash hands, go to stations to keep clean, do we allow them to essentially have that time paid off or have an extra break time that we didn't already have? What about, I'm going to get to this in a second in a little more detail, either flexible or remote work arrangements. We know that remote work is really encouraged. It is for instance, in the New Hampshire executive orders. If we can work remotely, we should continue to work remotely. But what about when we get back to work? Maybe it makes sense, depending on our workplaces, to allow people to have flexible work hours. So not everybody is showing up. Our building is 20 floors, so not everybody's showing up at the elevator banks at 7:30 in the morning. Maybe it works well for us all. And also thinking about anti-retaliation and anti-harassment provisions. Those provisions existed before now, but we don't want anybody to feel picked upon, feel discriminated, feel retaliated against because they suffered from COVID-19 or because they needed to be out. And maybe there's some resentment that they were allowed to be out of work, but I had to come to work every day. Next slide, please. So remote work. I think a lot of us pivoted very quickly when we realized remote work was recommended and in fact required in some instances. And maybe we just didn't have time to catch up with what we really wanted for a remote work policy in our haste just to do the right thing and be safe. And now is a time that maybe we could take a deep breath and figure out, okay, can we put a policy into place if we don't have one already that talks a little bit more about what the expectations are of us? What about work times? Where do we work? What are the logistics of working remotely? And, for instance, keeping track of our time, what we do or don't want to be doing for work, and what are some workers' compensation considerations? If I'm working remotely and my home office is my home office, and I go down to get a midnight snack at 11 o'clock, I don't think that converts into a workers' comp injury when I trip and fall getting an ice cream at 11 o'clock. So these types of considerations now we have a greater chance to think about. Next slide. And flexible work arrangements. There are some laws in some states that require such things to exist or require you to at least have a dialogue with an employee or an employer. But maybe now more than ever, if we weren't thinking about this as a great option, maybe now it becomes a really attractive option for both employers and employees. We've heard a lot over our ECHO time period together on COVID-19 about safety concerns, about social distancing, about disinfecting. Matt and Jenny have talked about what Hypotherm was doing. And having these flexible work arrangements might really play well into those types of considerations. Next slide. So to turn to the EEOC, the Equal Employment Opportunity Commission, which many of you may know is the federal agency that oversees various areas of protected characteristics such as gender discrimination, race discrimination, national origin discrimination, etc. And one of their areas of oversight is disability discrimination. So in our resources at the back of the slides, but I just wanted to bring your attention to it here. There is a great resource that they have put out relatively recently and updated about what you should know about COVID-19 and the ADA. Great resource to look at, it has some really specific questions. So if we get into the ADA, next slide, please. These are some issues that do come up because they come up very naturally when we're dealing with COVID-19 because we have folks that are sick or worried about, or they're concerned that they are exhibiting symptoms, excuse me. So the ADA generally does not allow you to ask as an employer intrusive medical questions about somebody's medical history. And we can understand that. The logic being, as an employer, you're asking those questions, and maybe you start to make some bad assumptions about what somebody can or can't do. Somebody should be allowed to have the full measure of all employment benefits and opportunities if they are disabled. And those types of questions can kind of lead to information an employer doesn't want to know and shouldn't know. But in this pandemic, the ADA now allows narrow questions to employees about COVID-19 related symptoms. And those questions can come up, for instance, when you're doing screening, as Matt and Jenny had discussed. And the questions still need to be narrow though. So it isn't supposed to ask a bunch of information about an employee. It's really supposed to be focused on the COVID-19 related symptoms. Employers can now take temperatures, again, in large measure due to this COVID-19 pandemic. They can ask employees to be tested if the testing is accurate and reliable. And they can require PPE. And there's a difference here that's interesting to me, at least. Employers can ask, as far as the EEOC is concerned, for an employee to submit a fitness for duty return to work note before they come back to work if they've had COVID-19 or COVID-19 symptoms. The CDC actually, and you'd think it would be just the opposite maybe, but the CDC says otherwise. And the logic being an employer shouldn't insist, as far as the CDC is concerned, on a return to work note, because in a pandemic, doctors' offices, hospitals, they may be just completely overwhelmed, and that's not something that they can actually provide. So there's where that tension comes up. Next slide, please. And so, as I said, I think last week, the week before, we're still operating within the same laws, even though times feel different. So to be ADA compliant, you still need to treat medical information as confidential. You still need to engage as an employer in an individualized interactive dialogue about reasonable accommodations. So what one person needs because they have a COVID-19 related issue, or they have some health issues that make them concerned that they are at risk, does not necessarily translate into one size fits all. And as you're talking with employees, or you're an employee yourself engaged in the interactive process, an employer should be allowing for reasonable accommodation absent undue hardship. And that's significant difficulty. That's not just this is bothersome. That is a very significant difficulty. Next slide, please. So when we're thinking about potential accommodations and how they interplay with COVID-19, we could be talking about things that, again, dovetail back into a lot of the guidance we've been talking about already. PPEs that are provided, maybe barriers, which we have all seen now when we're out and about in more of a retail setting. Maybe there is an elimination of marginal job functions. You know, yes, that was part of what I did before, but I really can still do my job without that side function, having to do that anymore. Or maybe, as we talked about a second ago, making temporary changes to work schedules or work locations. So just some things we can be thinking about as employers, as employees, working together to try to stay safe and to try to accommodate people's ability to get back to work. Next slide. And again, some good resources here. There are some great, the Job Accommodation Network is phenomenal. Many of you may have worked with it or consulted with it before, but it is, I think, a lot of fun to look at because it gets all sorts of ideas in your head that you might not have otherwise had about how can we work through a challenge or a problem. And Dr. McClellan had also provided workplace strategies for mental health, which is a great resource to look at. Next slide. So to switch gears a little bit, I wanted to give you this resource up front and also in the resource section of the slides. The USDOL is in charge of overseeing this new form of leave that we all have available to us, the Families First Coronavirus Response Act leave. And I say all of us, and that is an overstatement. It does apply to employers who have 500 or less employees. So the big employers, it doesn't actually apply to. But the USDOL has come up with some phenomenal questions and answers and information, and you can access them through this, this link. Next slide. So the purpose of this is not, my discussion here is not to do anything more than the 30,000 foot view of the FFCRA leave. It really is just to flag it for you and know that if you've got questions, there are some incredible resources out there that will answer a lot of very detailed questions. So essentially, you now, as of less than 3 months ago, there are 2 new forms of leave available, and they will extend through December 31st of this year. One is paid sick leave, and there are 6 reasons for paid sick leave. Generally, they are you have COVID-19, or you are waiting for a diagnosis about COVID-19, or you have been quarantined by a healthcare provider, or you are caring for folks that are family members who are in that same situation themselves. And then there's also expanded family medical leave, which involves the care of a child due to school closure or daycare closure, and nobody else is available to care for the children. I should say that that same reason is also under paid sick leave. It's one of the 6 reasons. So if we could get to the next slide. This is not an area to kind of think that you can intuitively understand. It's really important to look at the regulations, and they're very straightforward in terms of being detailed, and look at some of this great guidance. So what you need to really look at is, are you a covered employee? Our employer, excuse me, are you exempt? Some employers are. What kind of leave the employee needs? What's the reason for it? Because remember that paid sick leave has 6 reasons to choose from, so you want to be clear. What's the interplay with the FMLA leave that you would normally have? It does not extend it out more than your otherwise would be available to you. What about intermittent leave? When is that possible? There are pay caps associated with this, so depending on what kind of leave you take would be also depend on what kind of paid leave you would be entitled to. And how does this all interplay with what leave you already had before all this started? So, and also what can you do as an employer, as an employee, to appropriately document the need for the leave? And that's actually very, very user friendly. It is not intended to be hyper intensive for documentation. Next slide. So when you are getting involved in this issue of do I need this leave? How do I ask for it as an employer? What do I do when somebody asks? Please consult those very specific resources because you want to be very detail oriented. But remember, in general, this leave provides some employee protections that are very good. The employee should be able to return to their job. Healthcare should be continued, benefits during the leave, and they can't be retaliated against because they needed to take that protected leave. Next slide. So COVID-19 has changed a lot, but it hasn't changed the prohibitions that are out there about employment-related discrimination, harassment, or retaliation. And some potential issues that we have been seeing or talking about during the pandemic is concerns and issues about national origin or race discrimination, age discrimination, assumptions that, boy, somebody is over 60, they're in a high risk group. I'm just going to make assumptions that they should or shouldn't be returning to work. The issues of disability discrimination that we had talked about a little bit. Potential issues about interference. I needed FMLA leave or I needed to be out on the Families First leave and I didn't get that leave and I should have, or you are mad at me because I took that leave. And disparate treatment or disparate impact issues. You know, you're doing something what seems to be neutral, but how you perhaps are bringing people, either putting people out on layoff or furlough or bringing them back to work, it looks like, or it appears that you're selecting some people in certain groups and not others. I apologize, I have a little background noise in Manchester. Next slide, please. Other return to work issues we may all come across at one point or another. I hope I'm not too disruptive with the fire trucks going by. One thing that has been happening a lot in my practice is that people are actually not wanting to return to work. And there are some very understandable reasons for that. Folks could be just nervous and concerned. But in some instances where we have had heightened unemployment benefits that are going on at least until July 31st from the federal government adding $600 a week, some people are saying, and they're correct, I'm making more money being unemployed than I am coming back to work. I think those are some issues we may be encountering as we get back to work ourselves. And how do we deal with those issues? How do we select who returns to work? You know, we're doing it in a sensible manner. What about need for additional accommodations once people get back to work? Maybe somebody didn't need a reasonable accommodation when we were all working together side by side in March, at the beginning of March, but now they do. And being open to that because things have changed and people's circumstances have changed. And there might be things that we need to be doing as we work with one another we weren't doing before. And pay issues. Has pay changed because hours of work have changed? Are we being careful that if we change somebody's pay and they're a salaried employee, we don't inadvertently dip below various salaried exempt pay levels? Next slide, please. In liability considerations. I think a lot of us are concerned about potential liability issues returning to work. Certainly that's what lawyers think about. Workers' comp claims, are they going to be more prevalent? My law partner, JP Harris, wrote a great article just a few days ago about our state and New Hampshire AG's opinion about workers' comp liability issues. And it's an open discussion depending on what state you are in. But generally, employees will, if they will need to establish they got COVID-19 by virtue of being at work, which is pretty tough to establish, as we can all appreciate. But there are other concerns out there about perhaps lawsuits by employee spouses who wouldn't be covered by workers' comp law. We're thinking about third-party liability claims by customers, by patrons, that we as an organization didn't do enough. And also there have been outreach efforts, not surprisingly, by business groups, such as in New Hampshire Business and Industry, the U.S. Chamber of Commerce, to reach out to legislators to say, this is a concern we're having. returning to work, making sure that businesses or healthcare providers or public sector folks are not being sued on account of COVID-19. Next slide, please. Again, some of the resources, I won't read them to you, but I tried to organize them by topic. And there's just some really great resources out there for you to take a look at. So we could get to the last slide, and we'll just scroll through accommodations. We've got employee screening, liability, and immunity. And this is more of a hodgepodge about return to work guidance requirements. I did find, in addition to some federal guidance, there were some very helpful things about employee screening, for instance, from the state of Vermont. So it's a bit of a list from a variety of resources that might be of help to you. Next slide. And above all, we are in this together. You know, I think it's scary for us all. We're trying to figure out what to do, and we're learning as we go. Just to finish where I started, the emergency orders from our various governors are really, really helpful to give us a roadmap. And to link that up to where I ended, I think it is very helpful as an organization to be saying, look, in terms of exercising reasonable care, in terms of trying to do things to make sure I was not liable for something, I didn't do anything that would get my organization sued. I think it is helpful to be able to point back and say, look, we were paying attention to the guidelines that were out there at the time, be it from the governors or be it from the CDC or OSHA, and we followed those guidelines. And that seems reasonable under the circumstances. So thank you very much. I know I went through a lot, and I'm sure there'll be time to answer or discuss things in more detail. Thank you.
Yes, thank you so much, Liz. A lot of great information there, and thank you for framing it as a learning process for all of us, because I think that's so important.